And good morning. Thank you for joining us. My name is Courtney Yaki, and I'm with the F&M Regional Growth Alliance, and here today representing the Business Navigator Alliance of South Central and Southeastern Illinois. Today's another hot one for us here in Southeastern, South Central Illinois. Glad that you're able to join us. Hopefully you're in some good, cool AC and ready to hear an excellent presentation. And that's what we have in store for today is a tremendous presentation discussing cannabis in the workplace. In 2019, Illinois became the 11th state to legalize cannabis for adult use, which became effective January 1st, 2020. 4.5 years later, employers and employees are still trying to navigate this new law. So for today's webinar, we want to dive into this topic, and we have two experts to guide us through the discussion. Starting off, we have attorney Brian Wacker of the Cook Group to discuss the legalities of cannabis use in the workplace. Then we'll hear from Chad Thompson, Corporate Human Resource General Manager for North American Lighting, on their approaches and policies related towards cannabis. But to start us off, who is the Business Navigator Alliance of South Central and Southeastern Illinois? Well, we are a 6-county regional collaboration who originated from working through a small business community navigator grant. Off to the side of your screen, you can see the partners. We've got Ronna Saga and Angela Griffin with Coles Together, Lori Miner with the Sullivan, Illinois Chamber and Economic Development, Risa Shaner with the Crawford County Development Association, Nora Swallows with the Marshall Area Chamber of Commerce, Bob Colvin and Freddie Schmitty with the Paris Economic Development Corporation, and yours truly, Courtney Yaki with the F&M Regional Growth Alliance. This group is charged with professional outreach and technical assistance for local, state, and federal programs. Our mission is to ensure that small businesses in our region are competitive and applying for necessary resources. And our goal is to position you for success by accelerating business recovery and growth. You can see the map on your screen to where the Business Navigator Alliance is located. Today's webinar is part of a series of business webinars we host each month. These webinars are scheduled for the last Thursday of each month, so please mark your calendars and visit www.ilbusinessnavigators.com, that's navigators with an S, and sign up for our newsletter, stay informed. We also host various outreach events, office hours, and offer one-on-one technical assistance. Again, visit ilbusinessnavigators.com to learn more. We will post a recording from today's presentation and additional supportive materials on the website as well. If you have any questions during today's presentation, please put them in the chat. We'll try to save all the questions for the Q&A session after both of our presentations. So starting us out today, we've got Brian Wacker. Brian is a partner with the Cook Group, a regional law firm with offices in the Midwest and the East Coast. He has practiced law for 15 years in Illinois and Missouri, with a heavy emphasis on representing employers, small business owners, and fiduciaries in litigation and risk management. Brian has given dozens of presentations to chambers of commerce and trade groups, providing topical guidance on current legal trends and new legislation relating to employee obligations, anti-harassment training, recreational cannabis, and drug and alcohol-free workforce policies. Brian lives and works in St. Louis, where he and his wife raised their 7-year-old twin. So Brian, you definitely got your hands full. You got 7-year-old twins. And I believe this month was a milestone. You just hit 15 years and practicing law, both in Illinois and Missouri. So congratulations there. And are you ready to present, sir?
Let's get it started. Thank you, Courtney. I would tell you the milestones these days are not how many years I've been practicing, but how many days I can get by with my kids without them driving me actually crazy. So in any event, thanks for the introduction, Courtney. I appreciate it. Appreciate everybody attending today. I'm going to be going first. I'm going to be speaking mostly to the legalities of the Illinois Cannabis Act and its interplay with some of the other employer legislation out there, and then I'll be passing it over to Chad Thompson. He's going to talk a little bit more about application and actually in the workforce itself. So and then we'll have a Q&A at the end. So I'm going to get started through this. As Courtney said, I've been practicing in employee-employer relations for most of my career, and I'll say that there's probably no topic that has generated more interest and uncertainty as cannabis and marijuana in the workplace, certainly in Illinois, which has been It's been around for about 4 years now, but also in Missouri as well, because we've legalized that in the past couple of years as well. So why don't we get started? Courtney, if you could go to the next slide, please. So a few things for our goals and agenda for my portion of the conversation. First is we have, I'm sorry, are folks having trouble with the sound? I just saw a chat that said there might be some audio issues. Are we?
I hear you just fine. Chad,
Okay.
can you hear Brian?
Perfect.
And Reese is confirmed hearing. So
Okay, great.
Megan, maybe try a different setting, and Brian, keep going.
All right, perfect. All right, so goals and agenda for my portion today. I'd like to talk about sort of the legal issues that are related to cannabis in the workplace. We'll talk about some of the training that is available and would be advisable for managing cannabis in the workplace. Understanding what reasonable suspicion means. I know a lot of you folks have used or at least heard of reasonable suspicion checklists and sort of how that's applied. And also talk about steps to take if and when detection of use of marijuana is suspected in the workplace. So if we go to the next slide there, probably go right through that one as well. Let's talk, first off, let's step back and let's talk about what we're actually here to talk about, which is marijuana and cannabis. So it is a hallucinogen. I understand many of us have had different experiences with cannabis, whether it's something you've used in the past on your own, or you know folks who have. So if I'm telling you something that you don't already know, I apologize. But let's sort of get the baseline first. So marijuana is that tobacco-like leafy substance, usually in chopped, dried leaves, and comes in various forms. But one thing we all know, it has that pungent aroma that you can really, it feels like we're smelling everywhere we go nowadays. Street names, things that you may be aware of, that your employees may be referring to it as other than marijuana or cannabis, your bud, weed, flower, wax. There's all manner of different nicknames that it has. We can go forward there, Courtney. So it may not be news to many of you, but marijuana is not just smoked anymore. I used to have a slide in this presentation that said it was not your father's marijuana, and I had a big picture of Cheech and Chong. It comes in all manner of vehicles now. Most prevalent, I think, are these food products. So you see them in brownies, candy bars, chocolates, baked goods. The dispensary that near I think in Collinsville, I think is known for having a lot of these lollipops and hard candies, things that are a lot easier to consume. And they can be consumed in different vehicles as well. Outside of just the food and smoking, there's these vaping, e-cigarettes, even CBD drinks, pills, lotions, things of that nature. And actually, as recently as a couple of years ago, at least, vaping, or those vape pens that you see folks walking around with, is at least the third most popular way to use cannabis now. So a lot of folks, you'll see those little metal pens where they call them one hitters, or one, they just kind of walk around with them. That's one of the more popular ones that you see, and you'll probably want to be on the lookout for folks in your workplace. Next slide, please, Courtney. So let's talk just briefly about the effects of marijuana and cannabis and the different ways that it's consumed. With smoking, there is a sort of that immediate absorption through your lungs. So if you were to smoke marijuana, it peaks in your blood within minutes, and that's where you receive that sort of immediate high that, depending on how much you smoke at a given time, can last for 2, 3, 4 hours. Most of a person's behavioral or physiological effects will return to sort of their baseline level within 4 to 6 hours after drug use, but it has been shown in studies, it's sort of, depends on the user. It's been shown that there could be residual effects in your system and behaviors up to a day or even 2 days afterwards. Eating, on the other hand, this is a sort of a slower absorption rate because it gets metabolized in the liver, and that takes usually an hour or two for that real high that the user is seeking to come to exist. And that high is usually a longer high. So depending on the strength or the style or whatever it is that you're consuming, that high can last for more than 2, 3, 4 hours, sometimes up to 8 hours. And your physiological and your behavioral effects are not going to get back to their baseline. You're not going to come down from the high, usually for something close to 9 to 12 hours. So these are, in terms of the employers being on the lookout for these are the ones that you probably have more concern about, because it could be something that somebody consumed the night before, come into work the next day, and they could still very well, as we'll see later, be impaired or be under the influence of one of these longer lasting cannabis products. So we go to the next slide there, Courtney. So marijuana, again, depending on how it's consumed and how much is consumed, there can be sort of a 24 to 48 hour hangover. And these aren't really the same symptoms as alcohol, as an alcohol hangover, but it could be something that affects the physiological and biological parts of your body for up to a day or two afterwards. Go to the next slide there, Courtney. So let's just talk about sort of the basics of drug testing. I may be telling you folks things that you already know, but federal and Illinois law do not prohibit Illinois private employers from implementing a drug-free workplace policy or program. In fact, it's very advisable, given these new laws or relatively new laws at least, that you do have. And in so doing, employers are able to prohibit the use of illegal drugs, alcohol, cannabis, and marijuana while working and or while on the employer's premises, and or being impaired or under the influence of illegal drugs or alcohol, or legal drugs and alcohol, cannabis, marijuana, while working or on the employer's premises. However, and if we go to the next slide, given the new the Illinois Cannabis Act legislation and these other laws that exist, there's a lot of nuance, and there are things to be aware of. So certainly you guys have all, if you're in the HR field, and if you have any employees, you're aware of these different federal and state legislation, the Americans with Disabilities Act, the Human Rights Act, Title VII, the Illinois Right to Privacy in the Workplace Act, and the Workers' Compensation Act. So there's going to be a lot of interplay. And so before we get into the Cannabis Act specifically, let's talk about each of those. Courtney, next slide, please. So the Americans with Disabilities Act and the Illinois Human Rights Act have a lot of similar overlap. And here, specific to this discussion, we're talking about the use of marijuana and whether or not that can have some interplay or be related to a disability that an employee could have. So stepping back, both pieces of legislation will say that in the pre-employment stage, it is prohibited for you as an employer to conduct a medical examination on a potential employee, but that excludes testing for the presence of illegal drugs. So employers can't ask applicants specific medical questions or require them to take a medical exam or even to identify a disability. But they can test for the presence of illegal drugs. So if we look at making sort of an example out of this, employers can't ask applicants if they have the disability, i.e. the nature of an obvious disability to them, rather. But you may ask job applicants whether they can perform the job with or without a reasonable accommodation. In this case, with or without what could potentially be the accommodation of using marijuana for a medical issue. Next slide, please, Courtney. So after a job is offered for employment, employers can condition the job offer on the applicant answering certain medical questions or successfully passing a medical exam. But that is only legal if it is applied consistently. In other words, this is an area that lawyers kind of make a lot of money on when these sort of claims get brought up. But in other words, are you consistently requiring applicants or new hires to answer the same medical questions or pass the same medical exams? You're not only asking certain folks of certain backgrounds or certain folks to do it. You have to apply that sort of policy consistently, so there's not some sort of arbitrariness to the requirement. Now, for current employees, I think, as you all probably know, employers can generally ask only medical questions or require medical exams if the employee makes an affirmative request for an accommodation, or if you have a reasonable belief that the employee is unable to perform a job successfully or safely because of a medical condition or here, a drug or alcohol impairment. Next slide, Courtney. And so when can you refuse to hire, or when can you pull an employee out of work or terminate the employee based on something like this? The answer is when there is a direct threat to the health or safety of the individual or others in the workplace that cannot be eliminated or reduced by providing a reasonable accommodation. And remember, any of these, in any circumstance, whether it's the accommodation is the use of medical marijuana or otherwise, that threat to safety or effect of the performance of the work has to be job related and consistent with the employer's reasonable and legitimate business necessity. Those are a lot of words that have a lot of different meanings to a lot of different folks. And I will tell you that a lot of attorneys make a lot of money arguing over those things. So these ADA and Illinois Human Rights Act claims can be very expensive because it's always a very fact-specific determination. Next slide, Courtney. So generally, again, with prescriptions and safety issues, what are the sort of the best guidance for how to handle the best guidance, and what Chad's going to talk about later, is having a policy in place, that addresses requirements for the disclosure of prescription or over-the-counter drug use that could impact that employee's ability to safely perform the job. Also understanding what you can and can't ask. You can't simply ask for require the disclosure of a prescription on its own. It has to be something that is related to that. It has to be requiring the disclosure of a prescription or drug that could impact the ability to safely perform the job. And then also having, if you are fortunate enough to have an MRO or somebody else who is there who can have a policy in place for the conducting or handling of positive drug tests if they come along. Now, note in related to ADA and Illinois Human Rights Act, the status of being a former addict and or the current status of getting treatment for addiction, these are protected characteristics of employees. So that is it's something that we have to be very careful of and mindful of when making determinations and putting together these policies. Next slide, please. So the Family and Medical Leave Act, FMLA, obviously everybody here probably has some familiarity with it. How does this interplay with substance abuse? Well, FMLA leave can only be taken when you're talking about treatment for substance abuse. It can only be taken, or it's only approved or required under the FMLA for treatment for abuse by a healthcare provider that is on referral from a healthcare provider. The notion of self-referral, that does not in and of itself trigger the requirement to provide FMLA leave for treatment for substance abuse. So for example, if an employee comes to you and says, I'm an addict, I need to go, I need some time off I need to take some FMLA leave in order to handle my addiction, that is not enough. You actually need to have a referral from a qualified healthcare provider in order for that requirement to be triggered. And that's because because of the employee's use of the substance rather than treatment does not qualify for FMLA. Again, I've got that here twice on this slide because I usually, kind of go point by point, but I think that's a very important point here to emphasize that absences due to an employee's use of substance rather than treatment does not qualify for FMLA leave, and you're not required to provide it. Next slide, Courtney. So there's interplay among all these acts that the FMLA and the ADA and the Human Rights Act. The ADA and FMLA, those are federal laws, and they do not recognize medical marijuana or illegal drugs as a medical treatment. That's currently, we'll see a slide later. That is because marijuana is still considered a Schedule I drug. There is a proposed rule that's been put forth by the Biden administration that would reduce it down to a Schedule III drug, which would change things considerably. But that rule, even though it's been proposed, is only in the comment period and it has not been changed. So as of today, marijuana and cannabis are still treated like all other Schedule I drugs, and therefore they are illegal drugs on a federal level. So employers don't have to accommodate an employee's disability or provide FMLA leave in order to use marijuana or these illegal drugs. But we have to remember an underlying medical condition for which marijuana is used may be considered a disability, which this creates a tension. What do we do when we're being asked to provide some sort of employee benefit based on the treatment of a disability with the use of a drug that is legal on the state level, but illegal on a federal level? So the idea is you got to keep up to date on the law and the drug classification. Right now, we know that it is Schedule I. I think it's likely to be rescheduled as a Schedule III, where it would have the same, where it would be treated similarly to a prescription drug, but that is not the case. So there are a lot of blog posts and things out on the internet right now talking about it being reduced. That is a proposed rule. It has not happened yet. Courtney, if you could just pop through to the next slide. And then finally, the last law we'll talk about just briefly is the Illinois Workers' Comp Act. That is an act that I'm sure many of you are familiar with as well. It says that it's unlawful for an employer to discharge an employee because they exercise their rights or remedies provided to them by the act. This means that employees employees can bring claims for retaliatory discharge or retaliatory action against an employer if the employees of defendants before or after the act, and that a discharge or an adverse employment action was related to their exercise of rights for workers' compensation. And remember, as with all these acts, when you're putting any sort of claim together, causation is not going to be met. That critical element for any of these claims to be valuable and to subject a employer to liability, causation is not going to be met. And this is where we will talk about later, if the employer can show and articulate that they had a valid non-pretextual reason for the action that they took, that they took the action, they discharged or terminated for a valid non-pretextual reason. Next slide, Courtney. So let's talk about the Illinois Cannabis Law, the Cannabis Regulation and Tax Act that we're all here for today. Again, as Courtney said, this is effective. It was passed in 2019. It was effective in January 2020. Allows residents and non-residents over 21 to purchase and use cannabis legally. Neighboring states, including my home state of Missouri, we followed suit not long after, mostly because I'm sure everybody in Jefferson City loved getting all that tax money. I've got some stats here that are from the first year, the 2020 sales. And you could see just in terms of the first day, week, 12 days, and first month, the sort of pent up demand that existed in 2020 for the use of cannabis. I've actually got some more numbers that I didn't get into the slide that are pretty staggering. So in the first year alone, in 2020, this is during the pandemic, so we'll see if that will, who knows what effect that had. But in 2020, in Illinois, $1.125 billion worth of cannabis was sold, medical and recreation combined, in 2020. In 2024, as of July 1st, 2024, so this is about 2 months ago, it was already over $1 billion in cannabis has been sold in Illinois. So there is quite a bit of demand for this. And I think we can smell it on the streets every time we go out there, and you can probably smell it on a lot of your employees. There is a lot of marijuana being smoked in the state of Illinois. And I don't think I'm surprising anybody by saying that. In fact, of that $1.1 billion this year alone, I just looked this up this morning, 850 million of that was for recreational. So only 150 million was for medical. All right, so let's dive into the act. We'll go over some terms, then we'll talk about a few things, and we'll hand it over to Chad. So the cannabis law, one of the things that employers always are concerned about is what can and can't we do. So here's what the employer can still do. The act does not prohibit you from enforcing drug testing policies, including zero tolerance and drug-free workplace policies. It does not prohibit you from telling employees they can't use, possess, or be impaired while on the job, performing the job, or in a workplace or on call. And it can't prohibit you from disciplining or terminating an employee for violating one of those policies you have in place. Next slide, Courtney. In fact, the law itself, it says exactly those things, that you are allowed to do each of those things. But however, you have to provide in any of these circumstances where you're going to actually discipline, terminate, or withdraw a job offer for violating one of these policies. The law does require you to provide that employee a reasonable opportunity to explain before taking the adverse employment action, the discipline or the termination. That's because we have to be, but in those circumstances, it is contingent on, the law is that the employee, if they were using marijuana for some sort of medical condition or disability, that is something that they have to have told the employer about first, right? And that is something that we incorporate into all of our policies at this point. Next slide, please. What is sort of what is one of the issues with the law that really hasn't been ironed out quite yet is, though, there's interplay with the Illinois Right to Privacy in the Workplace Act. So the Cannabis Act says, except for provided in what we just talked about, it is illegal for an employer to refuse or terminate or treat an individual differently based on their simple use of lawful products off premises and not while not working and not in the workplace and not on call hours. And the law is very clear that the idea here is that you can take adverse employment actions against employees for their use in the workplace, while on call, while working, for being impaired, but you cannot do anything. You cannot make any adverse employment action against an employee for their use of it while not working and not on the workplace. So what do those terms mean? Let's move to the next slide, Courtney. The workplace. So this is not just the building. So workplace under the law, it includes buildings, real property, parking area, any physical location that is under the control of an employer, or any area that is used by the employee while performing the job duties of that employer, including vehicles leased, rented, or owned. In fact, as we've been drafting these policies, I think it could also apply to areas of the home. If you have folks who are working from home, having or possessing or being under the influence of marijuana in those workplaces, if you are on call or performing duties of the job. And that's why what is good about the law is that it specifically provides that the employer can, in their written employment policy, create a pretty broad definition of what workplace means for specific employees. Next slide, please, Courtney. We also talk about being on call. So what does on call mean under the Cannabis Act? It means that when an employee is scheduled with at least 24 hours notice from the employer to be on standby or to be otherwise responsible for performing tasks related to his or her employment. And this can include either being at the employer's premises or previously designated location where that work-related task is taking place. Next slide, please, Courtney. So what are some additional protections for employers under the Act? So there is nothing in the Act, and this is very clear that in the language of the Act itself, that says it creates a cause of action, or that's legal speak for the ability to sue an employer for any action that an employer takes, including discipline, termination, or any other adverse employment action, if the employer had a good faith belief. They don't have to be right, but had a good faith belief that at the time the action was taken, that the employee had been using or possessing marijuana while in the workplace, performing the job or on call, or had been under the influence or impaired in any of those situations. Additionally, maybe this isn't great for employers, but why we want to have these workplace policies in place is third parties. So be it somebody who came into your office or somebody who one of your employees ran into with their car, third parties may have claims against employers for injuries or damages caused by the employee if the employer knew or had reason to know that the employee was impaired at the time. And so that is why, again, another great thing for an employer's attorney by battling one of these claims is to have a strong drug-free workplace policy that we'll be talking about in a minute. Next slide, please. So what are the legal exposures and claims here? Certainly there's the right to privacy in the Workplace Act. I don't know if anybody has had one of these claims brought against them, but it goes through the Illinois Department of Labor. There's an administrative process where the department tries to resolve it. And if not, those remedies don't resolve the claim. It does provide employees the opportunity to sue for violation. This would include damages and attorney's fees, which is really the big problem with one of these claims is that they can be very expensive. Next slide, please. What other liability risks are there for use and impairment in the workplace? You could have claims brought against you for negligent hiring or retention, negligent supervision of your employees. But then employees themselves, if you don't have a good policy in place, or you violate the policy or you violate the act, they could have claims for wrongful termination, disability discrimination if the use is based on a disability, and third-party claims, and we talked about earlier, that could potentially put an employer at risk if something bad were to happen to a third party. Next slide, please. So one of the things that I think that Chad will be talking about, and that is very important, is that you have to understand this sort of shift in the idea from use to impairment, because use of marijuana does not actually equate to impairment. So that means that the most defensible position for employers still is, if you are able to determine impairment, how do you do it? Well, you document symptoms by a trained manager. You have an MRO or a drug test policy in place where you can show that there is presence of the drug in the body. Now, presence does not mean impairment, but it is a factor that goes into that determination. If you then provide employees the opportunity to explain, and then you have a strong team or you have a strong process in place to make determinations and what to do after their investigation into whether someone is impaired has been made. Why don't we? Yeah, so let's go to the next slide. I'm good. I am running up on time, and I don't want to take in too much of Chad's time, so we might pound through a few of these. Again, let's talk about federal law really quick. I talked about this earlier. Right now, it still is a Schedule I. Marijuana is still a Schedule I substance. It's treated at the same level as heroin, LSD, all the worst drugs you can think of out there. But it was proposed in May to be reduced to Schedule III, and this could have serious implications not only on how and how it's regulated, but certainly how employers are supposed to use it or supposed to apply their policies. Again, I want to be clear that hasn't changed. So we are still under the assumption at this point that marijuana, it's not an assumption, it's the truth. Marijuana is a Schedule I drug that's treated as harshly as any other drug. Next slide, we can go through this quickly. What are the best recommendations? What are the best strategies? And we're going to talk about this. We're going to update our policies and forms. We're going to define what workplace and on-call mean in those policies. And we're going to have some sort of a reasonable and enforceable procedure to proceed on if there is reasonable suspicion that an employee is impaired during work, while he's working in the workplace or while on call. Let's just pop through these really quick. Courtney, I've got a slide here on and all these slides will be available for you folks afterwards. Different types of tests that are out there. I know that many of the folks out there have MROs that they can use to conduct these tests. But one of the things I really need to be clear on is that at this point, there is no substance test. There's no actual drug test out there on its own that can measure impairment. It can measure use, but it can't measure impairment. So next slide, please, Courtney. We have these different types of testing, which I know a lot of you have probably all had different experience with. I think we're going to talk mostly today about reasonable suspicion, but there are other types of testing that are out there. Next slide, please. When we are testing, what is the result of what does impairment? Is there a level to say that a certain level in your body is a determination of impairment? Well, we can look at what Illinois has done, the state has done in terms of saying what is impairment while driving while impaired. There's a presumption of impairment under the law if the THC levels in the blood are 5 nanograms or more in blood, or 10 nanograms or more in any other bodily substance. If it's lower than 5 nanograms, there's no presumption, but the presence of lower than 5 nanograms and more than 0 is still a fact that can be considered by law enforcement to determine if there was evidence that that person was in fact still under the influence with that lower level. Next slide, please.
And Brian, if there's some major things that you want to hit on this, so definitely we're getting further into our time here, but
Yeah.
as everybody is familiar, if they've been with us before, if this is your first time on a webinar with us, we do schedule these for an hour. We do leave a half-hour buffer to allow for if there is an extension of a presentation or a great discussion during the Q&A section. But we will have a hard stop at noon. Just want to make sure that what you have to say is you get the opportunity to present. So definitely continue on, but don't feel pressured. We'll give Chad plenty of time as well.
All right, great. All right, so what is important? One of the things I really want to hit on, and that what I think Chad's going to talk about too, is how do you have a policy that works, that's enforceable, and that's not going to get you in trouble for doing it? And I think the most important thing here is having your employees, specifically your managers and supervisors, being trained and understanding exactly what it is that they're doing. So with respect to drug and alcohol, we talk about reasonable suspicion training for managers and supervisors. If you've got federal contracts or anything with the Department of Transportation, they have a training video out there that I think is very helpful to look at. Legal training, you guys are here on, being trained in webinars, talking to attorneys, talking to your in-house counsel about what the state of federal, state and local laws are with respect to testing, and then conflict resolution, right? So what do we do in the event that there is actually something that comes up? What if we have reasonable suspicion? What if there is a conflict that arises with that employee that you've put through the reasonable suspicion checklist? Figuring out conflict resolution, training managers and supervisors on how to handle difficult situations with employees. So next slide, and we'll talk about reasonable suspicion, right? So what is it? I've used that term a lot, and I think Chad's going to talk about it too. But reasonable suspicion training is, what do we do when we have a belief, a good faith belief that somebody is impaired or somebody is under the influence of marijuana or cannabis while in the workplace? And really, I think that while we talk about training and management, here are the items that we want to go through. The supervisor's role, your policy, types of drug testing, we talked about that. Company's process for drug testing, making sure management understands what that is. Do you have reasonable suspicion forms like the one Chad will show us later? Recognizing behaviors or conduct that would demonstrate impairment. This number 7 might be the most important one, at least for me as an attorney, because I see these things after the fact. Documenting behaviors and conduct, documenting what you were doing after you decided to conduct reasonable suspicion investigation, and then how is the management going to actually confront the employee when that suspicion it exists. So let's talk briefly about each of those as we kind of pound through these next slides. First one is role of supervisor. So the supervisor, in my mind, is the idea that the supervisor has to be a role model. They've got to not only enforce a policy, but they've got to educate the employees on what the policy is. And oftentimes that is more than just saying we have a policy, I'm going to email it to you and read it. It's hey, we're gonna have a meeting every 6 months, and we're gonna explain what this actually means. There's been some questions about it. Let's clarify what this means so we know that the employees have an understanding of what it is that they would be subject to if they were going to be called out for potential use or impairment. So again, knowing the rules, and then that supervisor should be trained on knowing and how to observe staff and know the signs, how to know, they should know who their employees are, have the ability to identify anything unusual or inappropriate, and then following the policy in place, actually following it, not making exception for your friends, not making exceptions for people that you like or don't like, following the policy in a consistent manner. Next slide, please. Talk about recognizing sort of common enabling behaviors with supervisors. Again, this is the idea that we have to talk to supervisors and management to enforce the policy in place in a consistent manner. This is, again, it involves training them to do this, because oftentimes in small businesses, especially, folks are reluctant to address hard problems because you have friends, you've been working with the person for 20 years, there's loyalty. And so you've got common problems like the supervisor or management will just ignore performance problems, or they will believe or accept apologies or excuses where, oh, it's just this one time and I had a problem. No, we have to recognize these enabling behaviors, because otherwise inconsistent application of your policy can only lead to bigger problems. So again, different things to train management and supervisors to avoid: empty threats, sort of accepting excuses that are not plausible or permissible under the policy. Or, we see this a lot with alcohol users, considering someone some sort of a functional user, right? We hear about the term functioning alcoholic a lot. That's an enabling behavior that management and supervisors need to be trained to avoid. Next slide, please. So we talk about areas of potential legal challenges. Reasonable suspicion testing. If you're not trained on it, you're more than likely going to get it wrong, and that's going to be the basis of a potential legal challenge. It's going to open the door for an aggrieved employee or the plaintiff's attorney to really assert a claim that you really don't want to have to deal with down the line. Other bases that can get you in trouble is if your policy is ambiguous and it doesn't really define exactly what it is that would trigger testing. And again, like I talked about before, inconsistent policy implementation. Unequal treatment is always going to be used to show bias. So whether they're your best friend or your worst enemy, if they're your employee, you got to treat them the same way. Whether they've been working there for 5 days, 5 years, 5 decades, they have to be treated the same way under the policy. Next slide, please. So just a couple of reminders in terms of what it is when you're going through and you make a decision after you've got some reasonable suspicion. Do you have to be right? The answer is no. You don't have to be right. It happens all the time. You move forward, but you just have to have acted in good faith. Now, is that going to eliminate potential legal challenges and liabilities in the future? No, but it's going to reduce it quite a bit. And how do you establish you acted in good faith? You have a policy in place, you've got a checklist in place, a reasonable suspicion process in place, and you apply it equally, and you apply it based on good faith observations of potential symptoms, facts, things that your management and supervisor have noticed. Next slide, please. So what are the criteria when we talk about reasonable suspicion? What are things that you can be looking at and talking to your management and supervisors about? I kind of broken it down in these 4 basic areas: appearance, behavior, speech, and body odor, which is probably the most, frankly, these days, most observable, because I can't walk down the street without smelling marijuana basically anywhere I go these days. So that is something that all things that you should be on the lookout for. Symptoms of marijuana, that's on the next slide, please. So the statute says that you can discipline or terminate if you have a good faith belief that the employee has manifested these articulable symptoms while working, right? So what does marijuana use do for employee performance? Well, it decreases it decreases, if you observe decreased or lessened employee performance, you see symptoms of speech, physical dexterity, agility, coordination being off or different from what that employee normally has, a change in demeanor, irrational or unusual behavior, if you see them careless or negligent in terms of operating machinery or equipment, not having the same regard for the safety of others that they typically have, or obviously if there's an actual incident itself, those are all things that symptoms or manifested observable manifestations of the use of marijuana that managers and supervisors should be on the lookout for. Next slide, please. We're going to see, I think, Chad's reasonable suspicion checklist later, but again, what does that checklist look like? I think it's sort of like 5 basic areas. First is understanding that you know what the warning signs are. If you do observe things, document those observable criteria in order to show why you even instigated the procedure to begin with. If you can get a witness there, all the better. Having a procedure in place if you've got a testing procedure in place, having someone escort that person to testing, then you make a determination. You go through everything. You find out in your checklist, all right, I've got all these different criteria, and then I've got to make a good faith belief based on, I'm going to set my biases aside, set my everything. I've been trained on this. What do we determine? And then you make a determination. Was there suspicion? Was there a suspicion of use? And can we determine that they actually were impaired during work hours or in the workplace? And then you take an action, right? The worst thing you can do is get to the point where you have made a determination of impairment, of a violation of your workplace policy, and then you don't follow through. So step 4, very important, take that action. And just as important, step 5, put a report together that documents the action you took and why you took it. Because the moment that you get, the first question you're going to get from your attorney when you get sued or you get a claim filed against you with the Department of Labor saying, hey, we got an employee who got mad at us because we fired him for he was clearly, he was high on the job, he did XYZ. First question I ask that employer each time is, all right, show me the report. Show me the file, show me your documentation of when it happened. And my job is a lot easier and your liability is a lot lessened if you've got that documentation contemporaneously prepared. You took the action, you sat down, you wrote the report. You didn't do it a week later, 2 months later. You didn't write it the day that you got the claim filed against you. Contemporaneous documentation, finalizing the report is critical. Next slide, please. So again, this is sort of recapping at least. What do you do if you suspect one? Well, you go through your checklist, you follow your procedures, and then you give them that reasonable opportunity to explain, right? If it's a medical user, someone's medical and they say, hey, I'm a medical user, you have to provide them the opportunity to explain why they were impaired based on their medical use before you make the decision. And if it's a recreational user, if the discipline is based on that employee being under the influence or impaired, you still have to give them the chance to contest the basis of your determination after the fact. So your policy is now going to have sort of a review period, so to speak, to give them that opportunity. You may know, in all likelihood, you're not going to change your mind, but if they can provide you information that can somehow change your mind or make your determination less certain, you do have to give them that opportunity. Next slide, please. Discipline considerations. So before cannabis was legal, my fail safe, and at any given point, if you found that someone was impaired with drugs while in the workplace, I didn't have much of a consideration. It was just like terminate, right? But there are other considerations now, and given that it is legal, sometimes there are things you might want to have a stepped policy in place. First violation is suspension without pay. Second violation is whatever. You can come up with things, but so long as you are applying those steps evenly and consistently with each of your employees. But again, if you find, and this is something that I've always said, if you have a problem employee that you're looking to fire, and you have any determination, and you've determined that you've had suspicion, but you haven't been able to fully determined that they used or were impaired or did something to violate your policy, remember, Illinois is still an at-will employment state. And so if you are concerned that by taking an action against an employee, they're going to have some sort of reaction or potential claim for violation of any of these acts we've talked about, let alone just the Cannabis Act, I always advised find the path of least resistance. Fire them because they're a bad employee. Fire them because you have documentation of poor performance over a period of time. Fire them for another reason, or just something that has nothing to do with any of these protected activities and classes that we've talked about. Next slide, please. Got just a few left. Again, so let's talk just generally again about sort of application of reasonable suspicion. Keep your eyes open. Notice changes in conduct, behavior, smell, appearance. Notify if you want to train not just your supervisors and employee or management, but also your employees. Notify humans. If you see something, say something, right? If you're working on a team and you know that there's one guy operating a forklift and he's pushing it the wrong way, train folks to go to human resources and let them know immediately so they can start the process of determining whether someone's impaired. Observe and document, observe and document, observe and document. Documentation is, in terms of coming from a legal standpoint, coming from the lawyer on this call, document what you're doing, document what you've seen, and have it consistently. Each time you do one of these, document it consistently. So when that call comes and when you have to call the attorney and say, hey, by the way, I'm emailing you all this documentation to show why this claim is baseless. And final slide, I think. So how do we address the employee? Again, I think that these are some sort of best practices that we can go through. It's all going to depend on the size of your company, what your policy says, but I think the overarching sort of concerns here are be confident, be respectful, and be consistent. Don't be confrontational. Stick to objectivity, to salient points. Don't be subjective. Don't have your managers and supervisors trained on being able to handle these in sort of professional, just the facts, ma'am, type of situation. And ultimately have a strong policy in place, which Chad's going to talk about now, and apply it consistently, right? Training folks to address employees and to handle the employee in the same way, whether it's, again, an employee who's been there for 5 days, 5 years, 5 decades. Consistent application of the reasonable suspicion procedure is the way to avoid these issues. So I think we can actually kind of go through to the end there. I think I've probably said these things 3 or 4 times already, Courtney. So I think at this point, I've probably gone over time anyway, but I will toss it over to Chad.
Thank you, Brian. Oh, wonderful presentation. Just tremendous, packed full of good information. I've taking notes and chicken scratches, and looking forward to go back and listening to it and diving into deeper. Thank you for continuing on. We definitely have hit close to the 1 hour time frame here. We're gonna continue to power through and have Chad coming up here next. Do hope that you're able to stay with us. Understandably, if you're not, you will get a copy of the presentation. You will get a link to the recording of this webinar that you can watch later as well, and so you can pick right back up from wherever you had to leave. But hope that everybody able to stay with us today. And Brian, again, always a pleasure talking with you. Always a pleasure listening to your presentations. Great job. You know, what I'm gathering from this, it's still a fine line, or maybe more appropriately, a careful line to walk for the employer. I wrote down, you know, use does not equate to impairment, and just a lot of things that you really got to pay attention to, and just make sure that you're documenting. And I was really taken aback from the statistic that you threw in there of over 1 billion in marijuana sales or cannabis sales in the state of Illinois as of July 1st. And that was 1 with a B, 1 billion with a B, and 850 million of that being recreation. That is tremendous. That is a lot. My goodness. But thanks for throwing those stats for us and really laying down what the market is current.
Yeah, and Apologies for going over, but I'm an attorney, so I bill by the hour. So
I hear you.
It's just what I do.
In the
I can't
nature,
break it.
in your
Yeah.
nature. Well, the
All
biggest
right.
thing was we wanted to get the info out there, and very welcome to hear the presentation from you. And we're going to continue on. We'll have a hard stop at noon. Plenty of time for Chad to go through his presentation. Chad, please do not feel rushed. We'll try to get some questions on the backside. And if you do have questions afterwards, not able to get them to, we'll follow up with people later too. But up next is Chad Thompson. Chad has been leading the HR team at North American Lighting, or NAL for short, for almost 8 years. NAL is the largest automotive lighting supplier in North America, starting production in 1984 in Flora, Illinois. Their customers include Toyota, Honda, Ford, Nissan, and GM. His team supports almost 6,000 team members in 7 locations across 5 states. NAL has 3 facilities in Illinois represented by 3,500 team members in the communities of Flora, Salem, and Paris. Chad has almost 30 years of human resource experience and graduated from Blackburn College. He serves on the F&M Regional Career Academy and F&M Unit 40 School District. Chad and his wife, Stephanie, have 3 children and have lived in F&M for over 20 years. Chad, are you ready to present, sir?
Yes. Good morning, everyone, and thank you for the introduction, Courtney. It's hard to believe it's been 30 years. I got to be honest, I never dreamed when I started that one day I'd be writing policies to comply with marijuana use or restroom use. I remember trying to write the first policy to make the offices non-smoking at World Color when I was about 23, 24 years old. But I will say I don't consider myself an expert necessarily. I like to think of HR as a practicing profession, much like a doctor or an attorney, because what we're dealing with is always changing. Like Courtney said, I've been with NAL for almost 8 years. A couple of my colleagues are on this call, Mandy Martin and Sarah Tomes. I also like to point out that we also have a location in Mattoon that we support, and that's where Sarah is located. And then just for reference, a lot of people don't know what we do at North American Lighting. I'm actually at the Flora facility where you can see behind me, this is the Ford headlamp that we manufacture at NAL, as well as the electric Hummer that you may have seen with the LeBron James commercials. We do that front lens there for them as well. But very proud to be with North American Lighting. Also want to make one shameless plug in the fact with my part-time position as a Unit 40 school board member. Those of you in Effingham County, we have a big election coming up in November about the 1% school facility tax. If you have any questions or concerns about that, you're going to get my contact information at the end. I fully support that program. And if you have questions, please don't hesitate to reach out. Courtney, let's go to the next slide here. This slide, just is some of the history at NAL since 2020 when marijuana became legal. It was the good old days when staffing really wasn't necessarily an issue. I can remember we didn't even accept applications some months in Flora and Salem because we had all the positions filled and had a waiting list of applicants. But back then we did all the testing for pre-employment, random, post-accident, zero tolerance. Those you may not be aware, North American Lighting is a Japanese-owned organization, very conservative, by the book, black and white type policies. And so it was a big step to try to comply with something like the marijuana use in Illinois. We were fully staffed, rarely used staffing agencies. Our turnover averaged about 2% a month. So annually, just under 25%, which if you're in manufacturing, consider that to be pretty good. In our employee assistance programs, our utilization was around 12 or 15 team members annually, which that has jumped dramatically since 2020. And I'll talk about that here in a moment as well. Next slide, please. Then 2020 came, and that's when my hair really started to turn gray. You'll notice that picture in my profile that was probably taken in 2018, 19, and then between COVID and the school board and trying to help manage programs both at NAL and at Unit 40, I felt myself becoming older and older, and the gray filled in. But the new cannabis law came in 2020, and initially, like with most laws that we get subjected to or what have you, we don't really get a lot of guidance. We really weren't sure what we could and couldn't do. We kept marijuana in there as a pre-employment screen. During that same year, we obviously dealt with the COVID shutdown, like many of you did as well, and we struggled to fill openings. Even when we started the plants back up, that's that summer of 2020, each facility in Illinois had about 100 positions that we just really couldn't get filled. And for one reason or another, we had people that took early retirement or just decided, they were going to try a different career. We removed cannabis from the screening and scaled back random testing in August of 2020, just simply because we couldn't afford to lose people due to that issue. And that's when we really started to implement the reasonable suspicion program, and then tied that to post-accident investigations as well. By 2021, I can still remember my son was a senior at the time. We were playing basketball AAU tournaments in Missouri, and on the way back from Cape Girardeau, I noticed a sign around Anna that talked about migrant workers in the area and so forth. And that's what gave me the idea that we needed to start recruiting out-of-state workers for our Illinois facilities just to keep up with demand. And to this day, we still have out-of-state workers that reside in Effingham that commute to the Flora facility. We're fully staffed at Salem and Paris at this point, but just like all of you, we've been through a lot. The turnover, it also spiked during this time frame. That 8% again is about an average for that year. We were really approaching 50% for the year on turnover. And we removed the cannabis, like I said, and scaled back the random. Next slide, please. Our current drug testing policy, what I can say is that we have to ensure team members are aware of the drug testing policy and understand they can't be impaired at work. And that means everyone. I mean, sometimes I think we make a policy and we communicate to our supervisors and management, but we fail to educate our team members as well as far as our expectations and so forth. We still do the 9-panel screen, cover most of the drugs that Brian spoke about. We still only do it on pre-employment, reasonable suspicion, post-accident. There's the different types that we test for, and we do utilize a third-party MRO, I should say, to manage results, just like I'm sure most of you do as well. We don't do any testing on site though, and this policy is ever-changing. And if your company doesn't have a good partner type labor attorney, I know I've worked with companies that had in-house counsel and those that do not. But it's important for you to have a partner because, as working in Illinois, the landscape's always changing. And it helps to have someone to keep your sanity, even to talk about a simple policy that change or a new policy. So if you don't have good legal counsel, I strongly recommend, I'm sure Brian, his contact information will be shared as well, because I think it's important for HR professionals to have that resource available to them. Next slide, please. As I pointed out, cannabis is still part of our drug screen. However, a positive test doesn't exclude you from employment unless you meet one of these different criteria. If you show up under the influence during the interview or plant tour, then we're not going to make an offer to you unless there's some extenuating circumstance that you're able to explain. If your background check shows a history of substance abuse or dealing drugs or anything like that, obviously that's going to weigh into our decision. In this day and age, there's quite a bit of information that you can glean from the radio or Judici that may give you pause on a certain candidate. And then, we do have a rehire policy, which I'll go through in a moment, related to whether if you tested positive for drugs. But if you test positive after you've already been released once at NAL due to unexcused drug use, then you're not going to be eligible for rehire at North American Lighting. Next slide, please. Now, when the law first came out, I thought that we would just follow DOT guidelines, because they have had established guidelines. Department of Transportation is what I mean by that, regarding alcohol, marijuana levels, things like that. But then we quickly found out that there's just no levels when it comes to urine testing, and so we had to develop a different strategy to assess someone's fitness for duty or their impairment. And so this is when we adopted the reasonable suspicion policy, which really wasn't huge step for us because we were already had some guidelines in place in dealing with alcohol use. But we upgraded the policy. The documentation obviously became a much more important aspect of the policy. And we also, and this was at the BICE, honestly, I believe it was someone at Horizon Health there in Paris that said, because they knew that we had first responders and EMTs at all the facilities because they help us with the training year to year. They said, honestly, those are the best people to have involved with these reasonable suspicion assessments because they're medically trained. And so we utilize them a lot. But sometimes they're not available. So that supervisor needs to have another witness. And so we train everyone, but we really try to utilize those first responders and EMTs. Next slide, please. This is a snapshot of our checklist. And again, if someone wants a copy of this, you can send me an email. I'm happy to share it. We have updated it probably 3 to 4 times since 2020. Just as most of your policies, you make these different adjustments and changes due to experiences with different situations. That's why, again, I refer to HR as the practice of HR because, you can have some obscure policies from time to time that have a really good story behind them. But remember, you can't have a policy that's going to cover every instance or situation. You have to manage those gray areas. Again, it's why you want to have a good labor attorney to coach you from time to time. And also don't just assume everyone can figure out how to complete one of these reasonable suspicion checklists. Your first responders and EMTs, they know how to do that, but they do need some coaching on some of the soft skills, as far as taking someone to a private area, making sure that you're compassionate, giving that person a chance to explain whatever issues they may be having medically during that situation and so forth. But just make sure that even your medical folks have some training on how to handle and administer the discussion in regards to the reasonable suspicion checklist. Next slide, please. And then don't just focus on supervisors for training. Make sure your annual compliance includes some slides about how to report concerns when it comes to drug use or alcohol use without the fear of retaliation. If you don't have annual compliance training to make sure people understand the key points of your drug policy, attach it to the end of your annual harassment training. I mean, I'm sure all of you know we have to have the harassment training annually here in Illinois, and sometimes we tack on a few slides at the end on important topics that we want to make sure everybody's updated on. And so you could use that opportunity to make sure everybody understands the expectations of the organization. I don't know about your supervisors, but at NAL, it's a tough job. We ask a lot of them. They wear multiple hats. And so we always want to make sure that they're approachable when it comes to this topic and that they feel like HR supports them, especially on the off shifts. And, we have a documented protocol and how we interview those folks, how they are accompanied, transported. On the off shifts, I can remember one situation where they were confused about what to do with someone that was refusing to have the testing done, and we're just going to drive home. And they were trying to convince the person they shouldn't drive. Ultimately, the supervisor made the right call, calling the police so that they could handle that situation. But you just want to make sure your supervisors know where that line is to where they call for police, and that sometimes if they're not sure about how to handle a situation, that you can also suspend someone. If you're getting a situation where it just feels like it's in over their head, they can suspend the person, say, hey, this is where we are today. I'm going to suspend you until further notice. If I'm wrong, you're going to get paid, but I just feel like I need HR support, and then, bring in HR whenever you can to help assess that situation. But make sure your supervisors know when they can contact you and what those limitations are or expectations that you have of them concerning this policy. Next slide, please. The reasonable suspicion checklist has also helped us better manage our post-accident testing, especially when it comes to assessing, whether the impairment had anything to do with the actual incident. Before we would just, doesn't matter what happened to you, we were going to test you. If you tested positive, you were gone. But now, as Brian pointed out, you need to make sure that if you're going to test people due to an incident, was it really due to their impairment or not? And so as part of our process, we're doing reasonable suspicion on every incident in regards to work-related accidents and so forth. But it's very important that you document everything. Brian said this. We strongly encourage that of our folks as well. And make sure, you know, as he pointed out, if there's other contributing factors or issues with the incident, if the person violated an OSHA guideline or a company, state, federal law or what have you, make note of that. Because if they do test positive, it's better to have the path of least resistance as well as multiple reasoning behind that decision. So if you're challenged on one, you've got something else to fall back on. Next slide, please. Just like any other complicated situation, the more cooperative a team member is through the process, the more options you may be able to provide that person on the policy. You know, if, in other words, NALs become more compassionate, supportive of those who may be struggling with addiction issues related to drugs or alcohol, for that matter, especially for our tenured team members. As Brian said, you still want to be consistent and fair about how you administer those policies. But if someone's being, you know, defiant and obstinate about the situation, and you're trying to communicate what their options are, and they're just refusing all that, then obviously it's going to limit their options or the communication that you can offer them, given the circumstances. You know, I've got a snippet here as from one of our policies on what we do with the refusal of a team member. You know, what we always ask management to not escalate a situation, to understand where their guidelines are. And, you know, the other thing that we've really enhanced as a result of this policy, as well as COVID in general, is that we enhanced our EAP program. And regardless, you must ensure management understands their role and to be professional and respectful and be aware of this EAP program so that they can, you know, share that with the individual, especially if HR is not available. We'll talk about EAP here in a moment. Next slide, please. Now, here are the steps we follow with the results. The MRO follows up on all results, then HR is the second contact based on what we receive from the MRO regarding the test results. Team member is suspended, obviously, pending those results. We get them usually within a day or so. They're communicated to the team member, like I said, by the MRO. If they're negative, the team member is paid for their time off. The team member will be consulted by the MRO regarding the potential protective factors, you know, if they do test positive. And then the MRO obviously shares this information with HR, and then we follow up with the team member to let them know, you know, what the decision is going to be related to the circumstances. And obviously confidentiality is an important factor. So we don't really have the supervisors involved with that situation or that communication at that point, and try to keep it all contained within the HR department. Next slide, please. The communication regarding the positive results is managed through the HR, I just said, not the supervisors. And retesting is only allowed, you know, sometimes, you know, you'll get a diluted response or something inconclusive on the results, and the MRO may suggest that a retest is in order. And obviously we follow those guidelines based on their professional judgment. You know, if termination is warranted, we communicate all circumstances that led to that decision. This goes back to, you know, Brian's comment about documenting other issues that may have been raised during the incident that could play into the reasoning for the ultimate decision of termination. And the other thing, it's important to make sure that the supervisors know that if they're asked about why that person is no longer there, it's, you know, either they pursued interests outside the company or they violate a company guideline. We do not get into specifics as far as a failed drug test or things like that. Next slide, please. I think we're just about finished here. Again, I mentioned this earlier. I think it's very important to have a strong EAP program with options for mental health. Ensure you have a program to support team members, just like alcoholism, and support team members that come forward before an incident. And I also recommend you test your EAP program. We had an incident where a manager was trying to utilize, we have a national EAP program, you know, with a toll-free number and all that. But he really struggled to get to the right person to help him with one of his dependents. And so then I just picked up the phone and tried to call it myself. And Mandy Martin, that's on this call, she also did. And we were a little stunned about how difficult it was through the prompting and so forth of this national program, that it really was not very compassionate, given the situation that when people get to that point or calling for assistance, that we knew we needed to enhance that program. And so we have now contracted with local providers on mental health, as well as we have a new national program to make sure, if people want to meet with someone personally regarding their situation, they have those options. And then we also have a virtual option, because sometimes, in the small towns that we're in, someone may be more comfortable with someone outside the organization on a virtual kind of like a WebMD type situation. And so we have that now. And, instead of 12 or 15 team members utilizing that benefit annually, we're averaging about 12 to 15 team members at each facility per month. And so it's made a big difference since 2020 in those areas, and to provide that type of support. Next slide, please. I will say that prior to 2020, we were not as open to providing people with second chances. But obviously, in the quest for talent that we're all in at this point, we did develop these guidelines in regards to eligibility for rehire. If someone does test positive and is released in NAL due to drug use, then they do have some options there that would allow them to come back to NAL. And again, if you don't have these guidelines, maybe you're fully staffed and so forth, but I would consider them if you're struggling to fill positions, because again, it's a situation where someone can make a mistake, and sometimes they can be very valuable team members when given that second chance. Next slide, please. And in summary, again, as Brian said, develop a solid drug testing program. Obviously, partner with a labor attorney. Make sure you train everyone on the policy and the company expectations. Ensure you're supporting your supervisors and how they manage, especially on the off shifts, because they don't have as many resources, and usually your more tenured supervisors and managers are on the day shift. And so make sure your night shift folks feel like they've been properly trained and have that support. I also recommend, besides partnering with a labor attorney, is to network with other HR professionals, especially if they're in your line of work, whether it's manufacturing or healthcare, what have you. Bush UHR in Effingham is a good resource if you're a smaller company and don't have all of the resources or other colleagues within your organization. I saw Rachel Collins was on here at Stevens. Her and I speak from time to time on different challenges that we work through. And again, I provide myself as part of this webinar that if I can ever help anyone out there in the area, please reach out to us. I've got a great team. So if I can't do it and I have someone else that's a little more of a subject matter expert in one area, then we're all in this together. We should start an HR support group for one another. So I thank you for your time, and that's all I have to share, Courtney.
Thank you, Chad. Oh, great presentation, and love hearing the employee assistance program that you guys have implemented, and just having those resources for your employees from a local level, and being able to provide those options on a virtual level as well. Something to definitely take note of, and love that you talked about, utilizing professional services wherever possible. And I strongly believe in that. And most certainly, as Chad had noted, reach out to your fellow people throughout your industries, reach out to everybody else and ask questions and talk. I mean, that's the only way that we're going to be able to move forward together. Everybody's facing the same types of issues. I believe a lot in regionalism, especially from the position that I have with economic development, and really how this come together with the Business Navigator Alliance. And if we're not helping each other out, what are we really doing? And it's really the best way to be able to grow and to move forward. So great presentation, Chad. Thank you for walking us through really how to navigate and what you guys are doing to navigate that employee-employer relationship, and ensuring that you're still providing a safe work environment, and to adhere to employees to their needs and desires as well. And still definitely a fine fine line to walk through. Very thankful of the willingness to provide the reasonable suspicion checklist. And if you'll send that to me after this webinar, we'll include that as a document that was sent out along with the presentation and the link to the copy of the recording that will go out next week. And we are going to jump into our Q&A session, which we just have a few minutes left. If you're still with us, thank you for continuing on, and thank you for joining us. And we're going to ask a few questions. I've had some come in via email. If you got any questions, throw in the chat. And if we don't get to them, realize we've got 7 minutes. We're going to try to, we'll follow up with them and send them out as a follow-up, portion of the follow-up as well. And really
Can I add one thing before we jump in those? And I just want to jump off of something Chad said. This is not a shameless plug for my own services or for networking generally, but I can't stress enough how important in putting these policies together. Mm-hmm. Not necessarily every time one of these incidents happens or every time you've got something to deal with, but in terms of putting the policy together and training of your employees and your supervisors and management, talking to an attorney or an in-house counsel or somebody you've used before, or networking with folks like Chad, people, trade groups, business groups or whatever, getting your hands on something else that somebody else has done that you say, hey, this maybe works better for us. It's the best advice I can give, because if our ultimate goal is to have productive workforces and improve our company's bottom line, it's penny wise and pound foolish. I mean, you getting it right on the front end, it reduces your exposure and liabilities and headaches and problems and everything else on the back end. So I can't stress what Chad said enough. If it doesn't have to be me, any attorney, any HR professional, stay up to speed on these new things. I mean, Springfield, they're changing things all the time. Every once in a while, some court will have some ruling that changes the calculus and how you kind of want to do things. We've got these change in the schedule of the drugs. Keeping up to speed, talking to people, networking. I can't stress it enough. It's very important.
Thank you, Brian. Love it. Love it. Thank you for reinforcing that. Utilize professional services to the extent possible. Tap into your networks. Leverage that human capital that you've been able to grow around you and throughout your field, and to and help each other out. At the end of the day, we're all still working to the same super-oriented goals, and we can work together. Love it. Thank you, Brian. Thank you, Chad. Most certainly. Please be willing to work together. Few questions, quick, like 4 minutes. All right. MRO was noted several times, Chad's presentation. Brian, you noted it as well. We don't want to assume that everybody knows the acronyms. Can you please, either Chad, can you detail what's an MRO?
Medical review officer. I want to take a guess.
Brian?
Yeah, I call it MROs, medical review. It's usually a third party that you've, if you're large enough to have an internal one, that's great. But it's a third party you contract with to conduct testing and help you with the stuff that you don't have the physical or the resources to handle in-house.
Yeah, we don't have a healthcare professional on staff, and so that MRO, sometimes it's within one of the hospitals that we're testing with, or through our third party Sterling that manages results as well.
Thank you. And just a few minutes left. Brian, I want to throw a question to you and really ask you to look into that crystal ball, if you will. And don't hate me for this one, but we discussed currently cannabis as a Schedule I drug and potentially could be moved to a Schedule III. And just recognizing that 38 states have laws towards medical cannabis, 24 states have recreational cannabis laws. What happens? What changes if there's a shift on the federal level?
Honestly, if we're talking, what changes with respect to Illinois employers and how we conduct everything we talked about today? I don't think a ton, right? I think what would sort of be what you'd want to be more concerned about is that, you no longer have what is, I think, an added maybe half layer of protection in terms of when you're trying to keep these things out of the workplace, where you could say, where in certain circumstances you could always kind of point to, well, it's illegal under federal law, right? Unless you have federal contracts and these specific situations, that would change a ton for you, right? Because then all of a sudden you have to kind of scale back what your prohibitions are and sort of the policies you have in place. But it's marijuana, just because it's going to be rescheduled, it doesn't change the effects it has on employees. It doesn't change the danger that impairment can present to other employees or the general welfare of the public if you've got folks using it before, during, or being impaired rather, while they're working. So when it changes, I think most of you would want to kind of go back and do a fresh look at the policy that you have in place. But if you're compliant with Illinois law, I don't think it's going to change a ton. And Chad may, unless you've got federal contracts, I think that's it's a whole different bag of worms. But I don't think a ton changes otherwise. I think you still are going to you still want to have a policy in place, and you still want to have it as strong as you can have it.
And we've all but at 12 o'clock, a quick question in the chat. If it's an easy one to answer. So when you perform any of these tests, do we use a 5 nanograms or 10 nanograms as the determining number on how or now for making business decisions?
I think I would maybe challenge the premise there. I don't know if it's a determining factor. I think the level, whether it's at 10, 8, 5, 2, the relative level of it is going to change how much you put into or rely on it in determining if there's been impairment. I will say though that if you have someone who tests over 10, you are going to be in a great defensible position to say, yes, this person is impaired, because that's what Illinois law enforcement uses with respect to the general public operating vehicles. So if it's at a certain height, 10 or above, then yes, I think it is your determining factor. If it's below, it's a factor, but it's not. It could be a very strong factor, but it's not going to be the determining factor. So I would just stress that something to vary. That's why we take the tests, but I don't think it's always going to be the be all end all.
Chad, did you have anything?
No, I would agree. I would agree as well. And, I would rely on the MRO to point that out to us, because really the only time we're going to get a reading like that is if a blood test is drawn, and the blood tests are only done whenever someone's in a severe accident type situation where they're taken to the hospital and, blood's drawn during the services or what have you provided there.
Well, we've busted the 12 o'clock hard stop now. It's 12:01. First and foremost, thank you, Chad. Thank you, Brian. Heartfelt thank yous. A lot of gratitude to you guys for educating us today. We hope that everybody found this webinar to be informative. Again, a copy of the recording, a copy of the slides. We're going to get the checklist from Chad will be sent out to everybody that registered. We appreciate you registering for these webinars and keeping with us on a monthly basis. Again, last Thursday of each month. September 26th. We will have ESOPs, employee ownership trusts, and worker co-ops. And so hope that you join us then, 10:30 on the 26th. Again, thank you, thank you, Brian. Thank you, Chad. And hope everybody has a good rest of their day.
Thanks everyone. Good day.